They can just find their seatings and stuff. I know some people might be pressured with a little bit of time, so we want to commit to that time that we are dedicating to this seminar. So just to start off, thank you all very much. Good morning to you all. I appreciate you taking a Saturday to come and spend this time. This is going to be something very educational. But I'll go ahead and start off first off by introducing myself. My name is Victor Manuel de la Rosa II. I am the Senior Financial Advisor for Mammoth Rock Investments, and we are a wholly owned subsidiary of Rice Federal Credit Union. To the left of me, my partner Sal. He is the other Senior Financial Advisor, and our President and CEO Arturo Bujanda. So this seminar is going to pretty much touch base on things on how to prepare and get things structured, alleviate headaches for the loved ones, avoid probate, avoid tying up that money, the cost that comes associated, little things that we'll be addressing in this seminar. And any age, it doesn't matter what age, it's very proactive to do that. Arturo has a little daughter, Lola's how old? 2? 2 years old, and she's attending this seminar because she wants to already do her estate planning. So it's never too late to start. So with that being said, this isn't going to really pertain to investments and retirement, wealth management. All that Sal and I and Arturo handle through Mammoth Rock Investments. So we provide all those services. Anybody retiring, planning on retiring, anybody trying to save for college for their children, their grandchildren, someone looking for better interest rates, better yields. We do CDs, market-linked CDs and all that. And this isn't a solicitation on our products, but this is just something to inform you all that we provide a service that's very vital. And the way that I see things is, if you look at it like a pie, a piece of the pie, a majority of you here probably have a lot of those slices of that pie. So you have your checking, your savings, your retirement, maybe some properties, different types of things that entail. But a lot of what we see that can be avoided I've seen the closest families, the most religious families get into arguments when someone passes away. And it just becomes something that can be a headache. Or some people don't even prepare. And by not preparing, it kind of restrains you, and you can't get really things too done. So we created a partnership with the law firm Kemp Smith. They have over 150 years experience. They are a very good firm that touch base on all legal aspects of litigation. Specifically here, we got Terry Hammond. He is the attorney for Kemp Smith, and he is the guru of probate, estate planning, and all that good stuff that is very important. So this is something that you can take in. If there's any family members or anybody who wasn't able to attend, you have our business cards. Feel free to send us an email, and we can send you the hard copies of the slide. That way you have some material to go over. Or feel free to contact us if you need an appointment with Terry. His business cards are there. Or feel free to also email us, and in turn we can go ahead and contact with them. I found one very special person right now, and I don't want anybody to get mad at me, but the San Francisco 49ers fan right here. So if you all are San Francisco 49ers fans, please stay. Everybody else. Okay, well, there you go. Bang, bang, Niner gang. So without further ado, I'm going to go ahead and introduce Terry Hammond. He's with Kemp Smith. And Terry, if you can kind of give a little background on Kemp Smith. And he's going to go into the slides. So if you could hold off your questions till the very end. We will have a section for questions and answers, okay? And what we'll do is, Terry will have a microphone. When we have the Q&A time, then I will take this microphone to whoever. That way, one person's story, one person's question may not apply to another person's, but it may apply to many people. So just keep an open mind. Understand this is nothing from the sense of investment strategies, anything like that. We will be having upcoming seminars, and these seminars will entail different things. I think our next seminar cell is Social Security?
Yes, I think so.
Social Security. We had a very good turnaround. that last year. So we'll go ahead and get that done. Anything you all want to say before we turn it over?
Enjoy it. Okay,
And smile for the camera.
Enjoy it, and again, he's a great asset for us. Okay,
I've seen through the 20 years of doing this, and it doesn't matter who you are. Some people don't have things prepared. So a lot of other banks, credit unions aren't bringing this to the table. So we do want to be that one-stop shop where we provide the investment services, wealth management. But at the same time, we want our clients, our members, our prospects to be able to have that known that there are things that you can avoid. So Terry will go ahead and get into that detail, but thank you all very much for coming, and I'll go ahead and turn it over to Terry Hammond. Thank you all.
Thank you, Victor. Well, so thank you all for coming out on a Saturday morning. I appreciate Victor's comments. It's really not so much a partnership, but a relationship we have between Rise Credit Union and Mammoth Rock Investments and the Kemp Smith Law Firm. Basically, we're in a position where we can contact Rise or Mammoth Rock if we have issues that they could benefit our clientele at our law firm with, and they can contact us or send you to us. And knowing the relationship we have with the credit union and with Mammoth Rock, we can feel confident that they are sending us people that they know, that they're familiar with. Often they're very helpful in helping us to understand the financial situation of their clientele so that people in our law firm can assist you. So I have practiced law since 1990, so 35 years. And for 32 of those years, I've done guardianship, estate planning, and probate law. I had my own practice here for 23 years, from 1993 till 2016. And I'm from Bryan College Station, Brazos County, Texas. And in 2016, I went to Brazos County, back where I grew up, and worked with the court system for 8 years. And then in January of 2025, I joined the Kemp Smith Law Firm. And I'm very proud to be an attorney, a partner at Kemp Smith. Kemp Smith actually had its origins back in Brazos County, where I'm from, in 1866, when the law firm was founded. And pretty quickly, it became a law firm that assisted a lot with the railroads, which at the time were being built across the state of Texas. And in 1881, the railroad came to El Paso, Texas, the Union Pacific Railroad. And Kemp Smith moved its headquarters from Brazos County, Texas, out to El Paso County, Texas. And Kemp Smith has been headquartered here since about 1881. So Kemp Smith has a long, long history in this community. I think it's a cornerstone of El Paso County. Kemp Smith has varied interest, legal interest in the county, from representing some of the, representing the city at times, representing the county at times, representing corporate transactions. There's a lot of business work done at Kemp Smith, a lot of employment law, a lot of litigation. And beginning this year, the firm decided to expand its presence in the probate, guardianship, and estate planning area. We have people who have done kind of high-end estate planning in the past, but now we have the capacity to work with kind of more normal kind of people. And so we have a couple of associates in the firm and myself who are working with people like you to meet their legal needs. And if you see the title of the program, it's Estate Planning, Guardianship, and Probate. And so it kind of covers 3 phases of a person's life. Estate planning, when the person is able to make decisions about their finances, about their planning, about planning for incapacity, planning for what happens with their estate, planning for their children, maybe helping parents plan for themselves or grandparents. And the estate planning part of this presentation is about what you do when you can kind of determine your future, and you still have the ability to do that. As people age and as people live longer, we have situations now more frequently where people lose capacity to make decisions. Maybe there's a head injury, maybe there's a stroke, maybe there's a dementia, maybe there's an intellectual disability where people are not able to do that planning. And you have to get legal authority to manage their legal affairs. So that can be an 18-year-old child who has Down syndrome, who you need guardianship for. It can be an 88-year-old parent or grandparent who is not able to make decisions for themselves, and maybe they have accounts at Rise or Mammoth Rock or elsewhere, and you go to the bank and you say, well, you know, Dad is no longer able to manage his account, and what happens when a person passes away and you need to go in and get legal authority. We have a case right now where there are accounts at Rise Credit Union, and we had someone who was in charge of an estate, and that person passed away, and I contacted the credit union, and I was told, yes, we will put a freeze on everything, but you need to bring us documentation from the court telling us who has the authority to make decisions on these assets. And so that's the probate process, the post-death process. And so we're talking about planning ahead of time. We're talking about having what you have to do when there has not been planning and decisions have to be made for someone who lacks capacity. And we're talking about the after-death necessity to get legal intervention and to manage a person's financial affairs after they have died. So with that, as Victor said, we're going to hold questions to the end. I'm going to be able to stay and answer some things one-on-one and the time that we have. So if you have a question that doesn't have kind of a general application where everyone would benefit from it, if it's more of a personal nature, let's talk one-on-one. As Victor indicated, you can call our office and we can set up a time to visit if you want to have a consultation of a more private nature. But we will get to the questions at the end. If something comes up and you just can't wait, you can't wait, you've got to ask it, then go ahead and ask it, and we will do our best to answer the question along the way. But for the most part, we'll do that at the end of the session. All right, so I'm going to go ahead and get going with the PowerPoint here. So, as I mentioned, we have ideas that we want to address during the course of this presentation. And those include learning about the importance of planning while planning can be done. It includes learning about what the key planning documents are. We're going to discuss what legal capacity is, because to execute documents, a person has to have the capacity necessary to sign off on documents that affect their well-being. We have situations sometimes where somebody sees a loved one, maybe a neighbor, losing capacity, and they take a power of attorney and go over and have them sign it. Well, that power of attorney is not going to have validity if the person does not have the capacity to understand those documents. And then that can be a serious situation because you could be investigated for fraud, for influencing a person who doesn't have the ability to make decisions. So you really have to do things by the book to make sure that everything has good legal standing. We're going to talk about guardianship and about how to avoid guardianship, because guardianship is a court process that you have to go and jump through a lot of hoops to get legal authority. Is anyone here a guardian for somebody? Okay, we've got a couple. If you've been through the process, you know that it's not like just going up and buying a hot dog at the ballpark. It is a lot of process, a lot of legal due process to make sure that rights are protected, and it's expensive, and you want to try to avoid it if you can. So we're going to talk about alternatives to guardianship. And finally, we're going to learn about the probate process, how you can avoid probate, and what you have to do if you do have to go through the probate process. All right. Let me ask, and this may not be a fair question, but I'm going to ask it anyway, just so I have a sense. How many of you are more focused on the planning part of things, getting affairs in order? You're not so much concerned about capacity or probate. You're here to talk about doing planning so that things will be taken care of in the future. How many of you are kind of here? Okay, a lot of you. Okay, good. How many of you are here to learn more about what you have to do when a person has lost capacity to make decisions and you need to do something in order to help them or to get authority to make decisions for them? How many of you are here for that? Okay, a good number. Then how many of you are here with a focus on the post-death process, going through probate and getting everything resolved after a person has died? Okay. All right, well, that gives me a better idea of where I need to sort of put my emphasis. Thank you for that. All right. So let's talk about planning to begin with. So there's a long body of law that has to do with giving someone legal authority to make decisions for you. And under kind of the law as it developed in Rome and then in England later, the state legislatures passed something called Durable Power of Attorney Acts. What a durable power of attorney does now is if the power of attorney has special language in it, and it says, Victor gets to make decisions for me if I'm unable to make decisions, then you can see how that can be really helpful, because if the coconut falls on my head, it's not like the coconut fell on Victor's head. He can make decisions for me even if I can't make decisions for myself. So now when we do planning, we have durable language in these powers of attorney that says that the authority to make decisions is effective even if I can't make decisions for myself. That can be medical and that can be financial as well. I think that, well, one thing I want to stress to you is that the powers of attorney can be effective immediately. Like I can say, I trust Victor so much that he has authority to immediately be able to make financial decisions for me. The power of attorney is effective immediately. Or I trust him so much he can immediately make medical decisions for me. You can put that in the power of attorney. Or I can say, well, I trust Victor, but I don't want him messing with things while I can still do things. So you can put in the power of attorney that his authority doesn't become effective until I become incapacitated. And that's called a springing power of attorney, where he's on the sidelines unless and until I can't make decisions, and then he'll have to get a medical report saying I can't make decisions, and then he can step in and go over to go to my doctor and begin making decisions, okay? So you can see how doing this kind of planning can be really, really helpful. And the legislature has given us forms to use. Now, we modify those forms sometimes, put some extra stuff in to make them stronger, but most of the powers of attorney are pretty much the same because the legislature has given us forms to use. You can also execute a directive to physicians, sometimes called a living will, that says, I do not want extraordinary means used to keep me alive. I don't want to be hooked up to a machine to keep me alive. If my quality of life will not be what I would want it to be, then I want to be left alone and allowed to die naturally. The living will can also say that if I'm on hospice care, then I want to have pain medications used to keep me out of pain, but I do not want hospital treatment. I want to be able to die in my home in a natural way with hospice assistance, but not with medical interventions. Okay, palliative care is what it's called. So that's part of the standard estate planning package, the directive to physicians. You can sign an out-of-hospital do not resuscitate order that says, and lots of times this is for people who are homebound, maybe have terminal illnesses, and it says, I want to direct that if I go into cardiac arrest or some other event happens, I do not want to be resuscitated. And you can sign that out of the hospital before you ever get into that situation. I talked about the durable power of attorney, the financial power of attorney. And we will touch on that a little bit more as we go along, but I kind of covered the basics on that. There's something now called a supported decision-making agreement, where if a person has a disability, some of you probably have relatives who have an intellectual disability, and they need help making decisions, but maybe they're high functioning and don't need like a legal guardian to make all the decisions for them. Supported decision-making agreement allows that person, the person with the disability, to designate a supporter to like help get access to the bank accounts or to help them talk to the doctor. It's a designation of a supporter to help them, but not to take over. So it's like kind of a partner in decision-making. So that's another planning tool that we have. The folks here at Rise and Mammoth Rock can talk to you about joint tenancy accounts or payment on death accounts, which is a way to do planning by contract with the financial institution that says what is to happen with accounts if you become incapacitated or if you die. By doing this kind of planning, designating accounts a certain way, you may have the chance to avoid probate altogether if everything that you have is in these accounts and the accounts say what is to happen to them upon your death or upon your incapacity. So that's another planning technique. You don't necessarily need a lawyer to assist with that. As Victor indicated, on the financial side, they can take care of most of those kinds of issues and the planning. Social Security representative payee. This is a way where if a person is receiving Social Security, I recently began getting Social Security. If the beneficiary of the Social Security benefits becomes incapacitated, a person who has proper standing can contact the Social Security Administration and can say, here's the medical evidence showing that Terry Hammond can no longer manage his Social Security benefits. I want to be designated as his payee so that I can manage those benefits for him. And that is a way to do planning that allows for the management of Social Security without having to go to court or do more legal intervention. Same thing with veterans benefits. The Veterans Administration can designate a VA fiduciary who can manage VA income on behalf of a veteran who cannot do that. That's another planning technique. Lawyers are not usually involved in either Social Security or VA fiduciary designations, but if there are issues or if there's a need for assistance, an attorney can help out there. Trust, we're going to talk in more detail about trust. A trust is something that you can say while you're alive, I want to create a trust and I want to put my assets in the trust. And it's like a bucket. And before the trust is created, everything is outside of the bucket. Maybe you've got your house, maybe you've got your vehicle, maybe you've got financial accounts. And the idea behind the trust is that you do the planning that puts everything, instead of outside of the bucket, it puts everything inside the trust bucket. And the trust bucket, the goal is to put everything in there, and then you can draft the trust in a way that allows you to manage everything you put into the trust for as long as you can. That's called a living trust. And the trust can say if Terry becomes incapacitated and can no longer manage the trust, then I designate my daughter or I designate my wife to become the successor trustee. And it just moves along without anyone in the outside world really knowing about it. It's a very private way to do things. It's a very personal way to do things. And if you do it right, and if everything works out according to plan, then maybe you don't ever have to go through the probate process, because the trust says, upon the death of the principal, let's say it's me, upon my death, then everything in the bucket gets distributed the way that the trust says. So maybe 50% to my wife, 50% to my daughter. You know, sometimes people make provisions in their trust for their pets. You know, I want X number of dollars to be used to keep Fido happy and healthy. And I did a trust one time, a pet trust, for a woman who had no family, and she had a lot of cats in her house. And she wanted the house to be used to keep her cats for the rest of their lives. And that was her whole planning, is all of her money and the house went to care for the cats. So you can do a lot of creative things with the trust. I hope I never have to do a pet trust again, because it was not an easy thing to do, but you can do that. And then a trust you can also, and I'm going to move down to the last will and testament here, you can prepare a will, and in the will you say, this is my last will and testament. Upon my death, I appoint Victor to be in charge of my will. If Victor can't do it, I appoint Arturo to be in charge of my will, and this is what I want to happen. This is who's going to get what. And then you can put contingencies in the will so that if my daughter predeceases me, then I want 100% of my estate to go to my wife. Or if my wife predeceases me, I want 100% to go to my daughter. You can actually prepare a will that has what's called a testamentary trust in it. And a testamentary trust says, okay, upon my death, I want a trust created, and the trust can take care of my minor child until they turn 25. And the trust can say at the age of 25, the trust distributes to the person. The testamentary trust can say, at the age of 25, if my child is married, then this. If my child is not married, then that. You can control all kinds of stuff from the grave through either a living trust or through a testamentary trust. And so sometimes people don't want to put everything into the bucket when they're still alive. They want to wait till they're deceased. And then the will says everything goes into the bucket, and this is the way it's supposed to be managed in the trust. All right? Okay, so those are some basic estate planning tools. Go a little bit more into detail about the difference between a trust and a last will and testament. I talked about an inter vivos trust, which is a living trust, and the testamentary trust. One thing about trust, as I mentioned, is that they are very private. If you file a will for probate, there are certain public filings that have to be done. There's an application to probate the will, and then the will is attached. So people can get into the cause number in the probate case and see the application to probate the will and see the inventory that's filed of your assets. That's very public. If you have a trust, then nobody ever sees what the planning is you did with the attorney. That's all very private, just for yourself or for your family, the people you choose to include. On the last will and testament, again, there are public filings. There's a filed inventory showing what your assets are. You have to go through a court. In El Paso County, there are two probate courts. El Paso Probate Court number 1, which is Judge Patricia Chu. El Paso County Probate Court number 2, which is Judge Eduardo Gamboa. You have all kinds of third parties who are involved with your stuff. That isn't the case if you've done a trust. Things go in front of a judge. Sometimes judges make certain decisions. The decisions they make may be what you want, they may not be what you want, especially if there's an irregularity with the will, like if the original is lost and you've got to probate a copy of the will. Well, you've got to prove up the handwriting, you have to have witnesses come up, the judge has to be satisfied that the copy of the will is a copy of the original will. There are a lot of things that if you go to court that other people are involved with. The probate process is more rigid. The trust, if you do a trust, it is more flexible, and again, you avoid the court. Wills are kind of difficult to amend because there are certain formalities that you have to have in a will. A trust is much more easily changed, an inter vivos or living trust. A trust allows you to provide more easily for contingencies. You know, if this, then that. If not that, then the other. Whereas you can do a certain amount of that in a will, but it is more difficult because you don't have someone you've designated managing it all the way from beginning to end. They've got to go through the probate process, get appointed by the judge so that they can get authority to manage the estate. A will has to be probated within 4 years of death. A living trust can be managed seamlessly from life into death and beyond. If you have a will that's not probated within the 4 years, then you've got to jump through a lot of hoops to be able to probate it, and you don't get to do it the way it would have been done if it would have been timely filed for probate. Probate process, you can have people come in and contest the will, saying that, well, you know, so-and-so was influenced by my sister, our dad was influenced by my sister, she shouldn't be the executor of the will. I'm filing an application to contest her application to probate the will. I want to be appointed, or I want a third party appointed. In a trust, usually you don't have those kinds of conflicts because of the way the planning is done. Trusts are pretty easy to modify. Again, with the probate, with a will, you have to meet the formalities of a will. Sometimes people do handwritten holographic wills. They don't go to a lawyer, they just write it out by hand. Then you see sometimes they scratch out things and add other things. And sometimes those wills can just be denied altogether because they're too impossible to understand. I had one when I worked at the courts where a person tried to amend the will on Post-it notes. So you have the document, then you have these little sticky pieces of paper, and you're trying to figure out, okay, how does all this go together? There can be tax benefits in certain situations. If there's a taxable estate, I don't do taxable estates, but there are people in our office who do. And as I indicated, the probate process is, I think, more open to conflict. If there's a problem with a trust or someone wants to make an issue, they don't already have an open case because the will's been probated and there's a cause number assigned. They actually have to file a lawsuit on their own, which is a lot more trouble than just coming into an already existing probate case. So there are advantages to both, disadvantages to both. I will say a trust is more expensive on the front end to do than a last will and testament. But if you have a situation where a trust really makes sense, it's worth it to do that. All right, moving along. Want to talk a little bit about capacity. A basic premise is that adults have the right to make their decisions because from the age of 18 on, they are presumed to have capacity, right? Now, there may be a person who's an adult who lacks capacity, and sometimes, those of you who are old enough, I think of the Andy Griffith show, how in Mayberry, everyone managed to just kind of get along. You know, you never saw anyone going to court to deal with something. Sheriff Taylor, wasn't it Taylor? Sheriff Taylor would just sort of like, if, who was the guy who was getting drunk all the time? What, Otis? Yeah, if Otis got drunk, he'd just let him sleep it off in the jail, and then, you know, they just worked things out in Mayberry. So sometimes there are people who are adults who have capacity issues, but the family finds a way to get by without having to go to court and get legal authority. We as adults have the right to decide where we live, who we hang out with. We have the right to make medical decisions. We have the right to own and manage our property. We have the right to contract, to marry, which is a form of a contract. We have the right to vote. We have the right to drive. We have the right to make our financial decisions. And until a court says you don't have those rights, then you do. And then the question becomes, well, what if a person gets to the point to where they really can't make their medical decisions? They can't manage their property. Maybe someone has moved in on them and is taking advantage of them. Maybe somebody is abusing them. There are all kinds of horrible things that can happen to adults. And so we have these presumptions, we have constitutional rights, but those rights may not be managed properly or for the person's best interest. We have a legal definition in our Texas Estates Code of an incapacitated person, which is an adult individual who, because of physical or mental condition, is substantially unable to, and doesn't say totally unable, just substantially unable because of a physical or mental condition, to provide food, clothing, or shelter for him or herself. Those are pretty basic needs. Food, clothing, or shelter, or care for their physical health, or manage their financial affairs. If a physician says that a person cannot do any one or more of these things, then we may have an incapacitated person. Guardianship is what we do when a person lacks capacity, but it should always be a last resort, and we should try the Andy Griffith Mayberry way of less restrictive alternatives, just finding a way to take care of things before we go to court. So there are alternatives. I mentioned the Social Security payee program. I mentioned the VA fiduciary program. Mentioned the powers of attorney. If there are things like that in place, then you may never have to go to court because the planning or the services allow you to manage things without court intervention. If a guardianship is considered, you have to have what's called a certificate of medical examination. This can be done by, if it's an intellectual disability, it can be done by a psychologist. If it is a mental condition other than intellectual disability, it has to be a medical doctor or a nurse practitioner with a medical doctor's approval. And the physician statement has to address all of these things that indicate what the level and degree of incapacity is and what kind of legal intervention the person may need. Intellectual disability, there's a time frame. The evaluation can be done 24 months before a hearing. If it's another diagnosis, it has to be by an MD or by a nurse practitioner with a physician supervision, and it has to be within 120 days before an application for guardianship is filed. We talked about supports and services, Mayberry. These are the kinds of things that can be done to possibly avoid a guardianship. And it's just how well can you meet the person's needs without having to go get a court order. It may be that if you explore these less restrictive alternatives to guardianship, but the folks at your bank or the doctor says, well, I know you're trying to do things without having to go to court, but we need to see some legal documentation that you can make decisions for this person. Even though we explore supports and services, it may be that you have to go to court to get legal intervention. If alternatives are not appropriate and guardianship is the only option, then you may need to initiate a guardianship proceeding with the courts. And we have a very special law in the state that allows someone who thinks there's a need for guardianship for somebody, but no one is stepping in, or maybe the family are not doing the right things, maybe they're taking advantage of a person. There's a way actually to write an information letter to one of the courts and say, I think that my next door neighbor may be incapacitated. Would the court please investigate the need for guardianship? There's a way to do that without you being the one to ask to be the guardian. But by far, most often what happens is that the person with the concerns is the one who brings the application and wants to have the legal authority. There's some people involved in a guardianship. There's a court-appointed attorney ad litem whose job is to advocate for the wishes of the alleged incapacitated person. For example, if I file for guardianship on Victor, and Victor says, I don't like Terry, I don't want Terry to have anything to do with me, I don't want him to be my guardian, I would rather, my sister be my guardian. That attorney ad litem's job is to argue for what the person wants, what their desires are, what their wishes are. The court can also appoint a guardian ad litem, and that guardian ad litem's job is to advocate for what's best for the person. Guardian ad litem can be appointed by the court and look at all the evidence, come back and report to the court, well, you know what? I don't think that Terry would be best. I think that Victor's sister would be best, and make a recommendation to the court, and the court considers that. The courts also have an investigator here. Each of the courts has investigators who will investigate the need for guardianship. A few kind of basic ethical principles of guardianship. The guardianship has to be narrowly tailored to a person's needs and should be limited only to meet that person's mental or physical limitations, and only as much as is necessary to to promote and protect that person's well-being. So people think sometimes of guardianship as being, well, you take away all the rights. The person is obliterated. They don't even exist anymore because the court has given guardianship to someone else. No, the law requires that the guardianship, if the medical evaluation says, he can determine where he lives, he can determine who he wants to be with, but he should not be managing his financial estate. That would be a limited guardianship just with regard to the finances and not with regard to the personal decision making. That's the way the system should work. Another policy issue is that the court should design the guardianship to encourage development or maintenance of maximum self-reliance and independence in the incapacitated person. And so what we try to do in guardianship is have them last only so long as is needed to get the person back to a functional state, if that's possible. And one example is Brian Wilson of the Beach Boys. Brian Wilson in the late 1980s, well, from the 70s into the 80s, had a lot of mental health issues, drug issues. Finally, a PhD are considered by the court, and if certain rights are taken away and certain rights are not affected, then the rights that are not put in the court order stay with the person. They're not affected by the guardianship or by the court, and the person's free to execute those decisions. There are a lot of due process protections in a guardianship. It's one of the reasons it's time-consuming and expensive is because the law requires that we do a lot to protect the rights of the incapacitated person, including the right to legal representation, the right to appear at the hearing, the right to a jury trial, the right to present evidence. There's a high burden of proof in guardianships. There's a right to appeal. So there are lots of due process protections in a guardianship. Who can be appointed as guardian? Well, really anyone who the court considers appropriate. There is a mechanism in the estates code that allows a professional third-party guardian to be appointed. And we have a certification process in the state where people can become licensed certified guardians. And a third-party professional guardian, you might want to operate on that. Thank you. That's better. Thank you. A certified guardian credentialed by the state of Texas, there's actually a way for a professional guardian to be appointed. Sometimes the court finds that there's such a big family fight that no one in the family should be the guardian. It should be a third party. Sometimes the court finds that there are no family members. The person's 98 years old and has outlived everybody and is in a nursing home and needs a decision maker. So we do have a third party option for guardianship in Texas. Just going to touch briefly, there's a way to do a temporary guardianship if there's an emergency. You can read in your printout about that. There are duties and responsibilities of guardians that really have to do every aspect of a person's life. If the court appoints a guardian, the guardian has to manage on both the person and the estate side. So our folks at the credit union and Mammoth Rock, if you come in with a guardianship order, they are going to make sure that you've done everything you have to do to qualify as a guardian, and then will respect that order and help enable you to manage the financial affairs of a person under guardianship. The guardianship goes until the person dies or until they recover well enough to have their rights restored, or maybe until there's a need for another guardian to replace an earlier guardian. It's really nice when you have a guardianship and things improve to the point to where you can get people out of the guardianship. And that should be the goal. Now I want to turn the corner and talk about probate for a minute. We talked about earlier the last will and testament. So now we're looking at a situation where, let's say, no trust was done, and there's a will, and you need to offer the will for probate, right? The person's deceased now. Compared with a situation where there is no will. And what do you do then? If a will was never executed, if planning was never done, then you have more work to do with the court than if there is a will. If we have a last will and testament, you have planning done in advance, you have clearly stated wishes in the will, you have an executor named. If it's a testamentary trust, that where the trust is created in the will, you have a trustee designated. You have beneficiaries designated. You have a distribution scheme for how the estate's going to be managed and distributed. You can eliminate a lot of the problematic issues if the will goes through probate, and you can contain the cost because you have a document, a valid will. You take it to the court, and if the will says, I want my executor to serve independently without court supervision, and if it gives the executor the authority to manage and sell property, and if it's properly executed, that will gets probated, an inventory has to be filed, and then the court loses jurisdiction after the inventory is filed. The court is out of it. So if all goes well within 90 days of a will being offered for probate, the will being probated and inventory being filed, the court's out of it, and then the executor goes on to manage the estate. So not as easy to manage as a trust, but it's a lot easier to manage than if there's no will. And again, if the person we're talking about never did the planning and is past the point now of doing planning, then you're looking at what's called intestacy. And intestacy happens when you do not have a will and you've got to go to the court and say, hey, judge, my dad's deceased now. He never signed a will. He has an estate that needs to be managed after his death, and I want to be appointed to be in charge of his estate. And the judge says, you're sure there's no will? Yeah, we've looked everywhere, there's no will. Well, then you've got to determine by heirship who the heirs of the deceased person are. That may be a wife, her husband, it may be children, it may be stepchildren. And in intestacy, and this happens a lot, going back to the frontier days, the state legislature said, if a person dies and they have a spouse, well, you think everything would go to the spouse, right? Died with a husband or a wife. No, no, no. If a person dies and they have a spouse, but the deceased person had children who are not children of the surviving spouse, the estate gets split between the surviving spouse and the children who are not that surviving spouse's children. And that gets complicated because lots of times these people don't get along. They like their mother or their father, but maybe they don't like their stepmother or their stepfather, right? And let's say the surviving spouse comes in and says, I'm the surviving spouse, I want to be in charge of my husband's estate. And one of the husband's children comes in and says, no, 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 I object. She's not going to be fair to us, to the children who are not her children. And then you have a contest. And the court's got to hear and adjudicate that contest. So not having a plan in place has consequences. And the court has a whole lot more involvement if the planning was not done or wasn't done correctly. And so you can ask for an independent administration. I have a wife and I have a daughter who is not my wife's child. Exactly the scenario I just went over. If I die without a will, my daughter and my wife can agree that my wife can be the executor or can be the administrator of the estate. And if all the heirs, since there's no will, if all the people who are heirs under the way the law is written agree, you can have an independent administration. And at the date of filing that inventory within 90 days, the court loses jurisdiction. That's nice when that happens. But if there's not agreement, then whoever is in charge of the estate after all the fighting is done is a dependent administrator. And a dependent administrator is like a guardianship of a deceased person where you've got to go to the court and ask for approval of everything that gets done. I mean everything. You have to get approval to pay a mortgage. You've got to get approval to get reimbursed for the funeral. You've got to get approval to pay for house utilities. You've got to do Mother May I for everything in a dependent administration. That's expensive and it's time consuming, and an administration, a dependent administration can go on for years. Okay? So the planning is really important. If there's a big fight, the court may appoint a third-party administrator, may appoint an attorney who none of you know to be in charge of the estate. Well, whoever the deceased person is never planned on that, did they? They thought everything would just be taken care of. Maybe they didn't think it was their problem. Now it's your problem. But the court can appoint someone completely disinterested. The court has to declare the heirship. You have to have 2 disinterested witnesses come up and testify. Yes, I knew Sally from the time she was 15 all the way up to the time she died. And the children, the spouse, are these people, and you have to have 2 people say that. Well, sometimes it's hard to find people who have known someone all their lives, especially if the person who's deceased has lived a long time. So sometimes we have to spend a lot of time finding witnesses who can cover the early part of their life and the latter part of their life, and when they were in the military service. It's complicated. Sometimes you have to go and find unknown heirs. Maybe there was a child who was adopted out early in the teenage years, Maybe the person had relationships. I mean, we've had cases where someone over in Juarez had a completely different family from the family here. You got to get into all that. The law says how the estate's to be distributed among the heirs who have been declared by the court. And there's a lot more expense if we have intestacy, okay?
If you have any specific questions, personal questions, his business cards are going to be here. Please, you can set up an appointment with him, and I'm sure he's more than happily going to answer any questions you have. I know some of you are already walking out, so I want to thank him, and if we can all give him a hand of applause, please. Thank you, Mr. Hammond. Thank you.